All right, this is part 4 of the accusation system. In this part, we're going to get right into it. We've already discussed the meaning of accusation, the meaning of accuse. Now, with those foundations already laid, let's move into this part of our discussion. So, on the assumption that a police officer doesn't operate under an oath of office, 4 USC 101, and under the assumption that this officer that's not operating according to a sworn oath to protect our constitutional rights is in a position to now levy an accusation or to accuse, and to manifest that accusation in the written form of a complaint or informant, to take that document before a magistrate or a deputy that has an oath of office, to have it notarized, and that becomes a part of the judicial operation that you are now associated with, and you now have a accusation or a charge against you that must be dealt with by a licensed attorney that practices bar in the particular state in which you live. Now, what I find to be interesting about that is this: the accuser didn't have to actually prove that you committed a crime according to or articulate probable cause, but simply wrote an accusation, a document. And the document becomes a part of a process that leads to a whole nother avenue of journeys that a person will ultimately be on. Basically, they started with an accusation from a person in a position of agency that doesn't even have an oath in the first place, that's in the assumed role of something that can be considered as false. And we'll get into that later. But this is what I want to talk about in this video. And we'll get to the next one.